Can a cross-petitioner in an Article 81 guardianship proceeding get discovery, including the APS file? To find out, you have to read Matter of Nunziata, but it's 6 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Nunziata. The citation for this case is 2021 New York Slip Opinion 021129, published by the Nassau Supreme Court on April 15th of 2021. This is not the final decision after the hearing. This is sort of a mid-hearing decision about discovery available in an Article 81 proceeding. The issue in this case is what kind of discovery is available to an interested party during a guardianship proceeding. It's a fascinating case, and I think I'm going to ultimately do another video about the actual holding after the hearing itself. But the background that's helpful with respect to this discovery issue and decision is that Article 81 of the Mental Hygiene Law, which talks about guardianship applications, is a special proceeding, which is therefore governed by Article 4 of the CPLR. And Article CPLR 408 talks about discovery available in a special proceeding, and it says it's only available with leave of the court. It's not like the regular civil action or criminal action where they have their own discovery rules and basically every case allows discovery. That's not the case for a special proceeding. And why is there a special rule requiring leave of the court? Because a special proceeding is an expedited proceeding. In fact, Article 81 is supposed to be held within 28 days of the filing of the signing of the order to show cause. Order to show cause is signed. Within 28 days of that order to show cause being signed, there should be an adjudication on the merits of the application. So the court has broad discretion of whether to allow discovery in an Article 81 or special proceeding. The 3 things the court has to consider is the requested information material and necessary? Those are the general rules of discovery generally, material and necessary. Is the request carefully tailored to obtain the necessary information? And will the request for discovery delay the proceeding? Because you don't want that. The other thing you have to know is that under Article 31, which is a general rules of discovery in the CPLR, things are privileged or confidential if the statute says they are, if it's attorney work product, or if it's trial preparation materials. These are things that are generally confidential. And under that first rubric of statute saying they are, the last thing you have to know is that Social Services Law 473E identifies APS files as being confidential. APS files are statutorily confidential. The things inside of them, the reports, the photographs, the names of the referral source, the written reports, they're confidential, but there's an exception. It says that they can be given to a court, made available to a court upon a finding that the information is necessary for use by a party in a civil or criminal action or determination of an issue before the court. Okay, so what are the facts here? The facts are that this is an Article 81 case where Nassau County DSS, the Department of Social Services, filed the application for a guardian for Nancy K. The petition was really long, more than 50 pages long, and it was full of allegations of elder abuse, financial abuse, emotional abuse. The main focus of the petition was to set aside advance directives executed allegedly by the AIP, the alleged incapacitated person, and to avoid the marriage with the AIP's spouse. So an interested party moved for disclosure of the so the spouse then cross-petitioned to get into the action and moved for disclosure of the APS file, wanted the entire APS file. Why? Because the cross-petitioner, the spouse, said it might be relevant and necessary with respect to the credibility of the APS witnesses, to establish a timeline of events regarding the complaints made to APS, regarding admissions or statements made about the AIP's capacity, and actions and statements made about the petitioner, the person who filed the application. The AIP and the petitioner oppose the court signing the request for disclosure, and the court then holds the motion in abeyance pending an in-camera review and conducts an in-camera review of the APS file. And the holding here, essentially by the court, by Judge Noble, is that the court has to conduct, or the court here does conduct, a full in-camera review of the APS file, addresses the fact that it's presumptively confidential, but then says most of this information in the APS file is already known to all the parties and been exchanged, such as DMV records, deeds, public documents. objective testing results like a mini mental exam, photographs and affidavits. But some documents are privileged, like the Protective Services for Adult Referral to Office of Legal Affairs. So the stuff that's privileged in the file would be things that are utilized by government to determine whether to take action. So APS is allowed to have an internal monologue or dialogue with people in the organization about whether to file. And also the things that are privileged are the referral source, the name, the contact information of the person who made the complaint. So basically the holding of this case is that the court can and should conduct an in-camera review of the materials if it's possible, if they are relevant, and allowed to be turned over. And in fact, many things are turned over and some things are kept confidential based upon Judge Noble's part-by-part review of the APS file itself. And that's the case of Matter of Nunziata with respect to discovery. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.